Good morning, everyone. This is Steve Hoffaker. I want to welcome you to another in our webinar series. I believe this is the third one we've had, all informative topics to help you be a better, more informed, more productive certified agent in place specialist. And we have another one coming up December 7th. You'll want to look for that on the calendar. That will be posted today or tomorrow, and you can register for that. And then we have January, February, and March's programs already agreed to, so those will be scheduled as well. And this morning is a extremely important topic because there's a lot of confusion in the CAPS 2 class about who needs to follow HIPAA, what is the HIPAA release, who actually is included in that, and we have an expert today to talk to us about that. I met Meredith many years ago. She took one of the first CAPS classes I was doing, and we've met each other along the way. So without further ado, I want to introduce you to Meredith Mull, and she will take over the meeting. Meredith.
Good morning, and you can hear me okay? Can you hear me okay, Steve?
I can.
Okay,
I don't know about everybody else. They're on mute, so I'm okay.
awesome.
So go ahead. And by the way, we are recording today, so go ahead, Meredith.
Okay, perfect. So welcome to CAPS and HIPAA. Am I supposed to follow the HIPAA law? My name is Meredith Mull. I am actually an occupational therapist by background. I'm also a certified HIPAA administrator. I've worked in the post-acute sector as an executive and a private consultant for over 20 years. I actually served as the HIPAA privacy and security officer for a very large healthcare entity for about 5 years. I recently graduated from the Johns Hopkins School of Public Health in Population Health Management, and I currently serve as the VP of Community Health Strategy for a national rehab services provider in 42 states. And my role with the company there is to take rehabilitation and physician care services into the home for seniors. And for our agenda today, we're really going to go over the purpose and history of HIPAA law and really who governs that authority of the law. We're going to give an overview of the information that HIPAA protects and what the law expects from those who are required to follow it. And we're going to walk through some specific scenarios about situations where HIPAA does or doesn't apply. I'm going to start out by mentioning again that the information that we are going to go over today should not be taken or seen as legal advice. So while I am certified in HIPAA, I am not an attorney, and all information provided during this presentation and the applicability of the HIPAA law to your individual business should be run through your legal counsel or your company compliance officer. So very important to note. I think it's really important first to understand what HIPAA is and why HIPAA law exists. And HIPAA stands for the Health Information Portability and Accountability Act. It's a federal law, and it was created for a variety of purposes, mainly to protect sensitive medical information of individuals like you and I. And as a consumer of healthcare services, this is why when you go to the doctor's office, you sign paperwork that shows you received their privacy practices. And that consent really gives them different allowances for using your information for treatment, for payment of your services, or for various other healthcare operations. And so practitioners, and when I say practitioners, I'm referring to anyone practicing medicine or offering healthcare services. But practitioners who are bound by HIPAA have to obtain this consent from you in writing by law. And there are some things that they need your permission for and some for which they do not. And that's a really important distinction. So some examples that require your permission and therefore protect your information are for things like using your information for target marketing and clinical research. Secondly, HIPAA is proposed to allow a person to have greater control over their health information, like what can be shared and with whom. So the HIPAA law actually states that you, as the consumer of healthcare services, own the information about you and therefore you should be able to access it or view it with some exceptions. You also have the right to know who else has access to your information in the event that you actually wanted to know. And this also has some exceptions. So these rights also give you the ability to request corrections of your medical record. You can ask for copies or request restrictions on the release of your information to others. And I want you to note that while you have all of these different rights, there are a host of exceptions to these, but I just want to kind of relay the general premises. It also gives you the right to know when your information was illegally shared or accessed, which is known as a breach. And we'll go over what that means later in a little more detail, but essentially, it allows you to know when your information was accessed or shared outside the law or outside your permission. But keep in mind that not all disclosures of your medical information need your permission, and not all of it is tracked. So if the information is used to treat you, if it's used to make payments to health insurance for your services, or if it's for the day-to-day operations of the healthcare provider or the physician practice, for example, for running their business or for their quality assurance, this is allowable without your permission. And the reason behind this is the rule can't be so stringent and give you so much control that it interferes with good healthcare service delivery. And lastly, the purpose of HIPAA is to help healthcare providers better care plan for their patients by having information readily available to them. And so this is why doctors don't need your permission to share your health information, let's say, with an emergency room physician, for example, if that information is going to be used to treat you and potentially save your life. HIPAA also creates some rules around electronic documentation of health records, and they want to ensure that it's protected, but that it's also easy to share. And what that means is protect all the information about you that sits inside of a computer or some sort of electronic, mobile, or portable device. So HIPAA has a really interesting history, and we're not going to go into significant depth on it, but since it affects all of us who use doctors, hospitals, therapists, etc., I think it's worth pointing out its evolution. So HIPAA was signed into law in August of 1996. So interestingly enough, before I graduated high school, there was no real protection by law around my health records and my health information. But a government entity known as the Department of Health and Human Services are the ones who created those first rules. And in 2003, those rules were expanded to what is known as the privacy rule. And that's pretty popular buzzword in HIPAA. And this rule really defined what we now call PHI, or protected health information. And everyone who it applied to had to comply by April of 2003. Then the HIPAA security rule came out after that original legislation around 2005. And that really provided the rules around electronic health records and billing electronically, because by then we were moving more towards a more electronic-based society. Fast forward to 2006, and that's when the enforcement rule was created. And that came out because the government felt like there were a lot of entities and organizations that were really dragging their feet with that 2003 compliance deadline. And so they really instituted kind of fines and penalties for non-compliance. Then you fast forward to 2009 when the High Tech or Health Information Technology for Economic and Clinical Health Act came out. And that legislation had a primary goal of compelling healthcare providers to use electronic health records. Use electronic health records. And that's partly because this provided better regulation over them. And 2009 also expanded upon the enforcement laws with the HIPAA breach notification rule becoming effective. And that rule required those who followed the law to have to notify you, the consumer, when they mess up. And then it also instituted some fines and penalties for those entities. And then the last rule came out in 2013 with the final omnibus rule, and that filled in some of the gaps between the HIPAA privacy rule and the high-tech regulations. So for example, it specified that providers need to have encryption standards. So if you're unfamiliar with encryption, as it relates to electronic data, it's basically taking that data in electronic form and scrambling it all up before it sends it over the World Wide Web, so that if it was intercepted by somebody who shouldn't have it, they technically wouldn't be able to read it. So now that we know the purpose and kind of how it came about, I think it's important to know who's actually in charge of HIPAA and who's responsible for enforcing all of those privacy and security laws and rules. And like we said, HIPAA is actually a federal law, and the government assigned the OCR, or the Office of Civil Rights, to enforce and basically police all the rules they came up with. And their job is to oversee all of the rules and those who are required to follow the law to make sure that they're following them. And so they investigate complaints, they investigate breaches from patients and individuals, they penalize offenders with fines and possibly jail time. So I think it's really interesting to note, though, that 60% of the time, the breaches that they investigate and penalize are actually electronic. And that really isn't surprising anymore in the world of hackers. And so when we talk about hackers, those are criminals who really seek to hack into organizations who have healthcare information of people in electronic form, and they essentially hold it for ransom until you pay them. And that's something in the healthcare world that's known as ransomware, and that's also considered a breach of the law. And that definition of breach here is placed on the slide. And although HIPAA is actually a federal law under the watchful eye of the government, some states have more stringent laws than the federal ones. And so when that happens, the practitioner or the organization has to default to following the state laws and rules. So you can see that it's very complicated and why you need to really understand the law and who it applies to, and then know which set of laws you actually need to follow. So when we talk about breach and what the OCR is supposed to oversee, we really want to understand the information that the government seeks to protect when it comes to your particular health data. And HIPAA is essentially concerned with what is known as protected health information, or PHI. So you're going to hear me say that quite a bit. And PHI is really a subset of what is known as individually identifiable health information, or IIHI. So I'm going to break this down for you a little bit. IIHI is information that describes certain demographics about you, like your age, your gender, your address, etc., in the course of receiving some sort of medical service. And so this is generally known as information that can be used to identify you and a medical service that you received. But HIPAA protects a subset of that information known as protected health information, or PHI. And that's really the marriage of information that identifies you, plus the addition of any of those medical services you received that is transmitted or maintained in any form, written or electronic. And so transmitted is key for you to remember, and this will come up later. But the important thing to know about PHI is that it protects your health data that was provided by you, that was created by your healthcare provider, or that was received from one provider to the other, that's transmitted or maintained by someone required to follow HIPAA. So that's a little bit complicated, but you can see that the PHI that's actually protected by the law is really a subset inside of what's called a designated record set. And so this is why it's so important to really understand the rules and have legal guidance if you're going to be in business for yourself as a consultant or a general contractor, and really understanding how HIPAA applies to you. Okay. And so interestingly enough, PHI remains protected for 50 years after you die. So there is some information that has higher levels of protection even while you're alive. And that's something like psychotherapy notes, for example. And any use of your psychotherapy notes for any reason requires your authorization, with a few exceptions. So at the same time, it also affords the doctor protections in using that information or sharing that information with you or others. So that's really why the law exists. Okay. So what does HIPAA expect when it comes to protecting PHI? Well, it wants to ensure that when you use or disclose someone's health information, it's at the very minimum necessary to get the job done. So the government expects that there should be reasonable effort given to ensure that only what is needed is shared and only with people who have the rights to see it. And they expect you to do this all the time. And the minimum necessary is actually a rule inside the privacy rule. HIPAA also expects that you won't breach or disobey the law. And so a breach of the law occurs when a provider or a person who must follow HIPAA uses or discloses someone's health information improperly, or someone who's not supposed to see it does. So for example, the ransomware incident we just talked about a few slides ago. What this means is rules were created, you have to follow them, and if you don't, it's considered a breach. And there are a host of exceptions to breach that are maybe unintentional or inadvertent, but they are very specific scenarios. And breaches are serious. They can come with fines or even jail time. And those fines and penalties often are determined by the type of information that was breached and how many people it affected, and maybe even how many times you have done it in the past. So the Office of Civil Rights has instituted an online wall of shame. That's what we call it in the industry. And it's where if the breach affects so many individuals, which is over 500, you have to self-report on their site, and it's open to be viewed by the public. So the screenshot you see here on the slide is a glimpse of that wall. And these incidents often end up in the media and often can cause some reputational damage. HIPAA also expects that providers that are bound by the law follow each and every one of their rules, and there are a lot. Okay, so some of these examples are that they expect you to train all your employees on the law, and that you have very specific policies and procedures for your employees on how they can use that information. They require that you punish or impose sanctions on employees who violate those policies when you need to or when it's found out. And that you only use or disclose a person's information as the law allows, and you track special circumstances in the event a patient wants to know how you've used their information outside of what's allowable. And then you have a person acknowledge your privacy practices and provide their authorization for sharing data as they own it, okay? You also have to appoint a privacy officer that is responsible for managing and overseeing all of this stuff. So that's kind of what they expect you to do as it relates to privacy. HIPAA also expects that you follow all the security rules that came out with the HITECH Act. And a lot of this stuff is very technical, so I'm only going to try and summarize it. But they expect that you implement or have a plan to implement all the security and technology safeguards of a person's PHI. And even if you can't meet the rule exactly how it's written, they want you to demonstrate that you've tried to meet it as best and as affordably as you really can. And so the rule expects that you reasonably protect all the information that you house that's electronic from being stolen, from being corrupted, maybe used improperly, or even from being destroyed from things like a fire, for example. So some examples of these safeguards would be having firewalls, antivirus software, having access controls like passwords that time out, and multi-factor authentication, that there are encryption and decryption solutions put on your email, and that you even have several types of file backups. And then they want your workforce members to know how to conduct themselves electronically when it comes to sharing and accessing people's health information, and that you provide those same sanctions like in the privacy rules if they're violated. And so when we talk about electronic transactions, we're really talking about things like submitting healthcare claims to insurance over the web, emailing health information, using electronic medical records through your employer, using apps on mobile devices that store that protected health information, or going online to a physician portal and looking up your medical record. Those are all examples of those kind of electronic activities. One of the most important things that you're going to learn today as it relates to your CAPS designation is who has to follow HIPAA federal laws and when it may or may not apply to your business practices. And I'll say this, and this is probably the most important thing that I'm going to say. If you are not bound by the HIPAA law, then HIPAA does not apply to you, okay? And one of the key takeaways from today is that if you present yourself to clients as following HIPAA, then you are required to follow everything HIPAA requires. And if you don't have to follow HIPAA rules by law, you should not present yourself or your business as doing so. So essentially, don't toss it around as a buzzword or write it down on business collaterals because it sounds cool or professional. HIPAA only applies to entities, organizations, or providers who fit one of two descriptions, okay? One of them is what is known as called a covered entity that you're going to see up here on the screen. And this is technically and by definition, a health plan, a healthcare clearinghouse, or a healthcare provider who, and this is key, transmits any health information in electronic form in connection with a transaction. So again, the key here is transmits any health information in electronic form in connection with a health transaction. And a transaction, by definition, is an electronic exchange of information between two parties so that you can carry out some sort of financial or administrative activity related to healthcare, okay? And so those are things like up here on this slide, coordinating patient benefits, billing for healthcare services, obtaining doctor's orders online, etc. And if you're not doing these things, you do not meet the definition of a covered entity, and therefore HIPAA would not apply to you in this instance, okay? And so if you're unsure if you're a covered entity or if you fit the definition of a covered entity in your business practices, you should consult your business or healthcare attorney. I have provided some links to some online tools and some information which can help you determine your covered entity status. There is a decision tool link here that's very user-friendly and a link to the government website that goes into detail on transactions that you could conduct that lump you into the covered entity category. And so the point of this is, if you're not a covered entity, don't market yourself as one, okay? However, if you are, you must operate within all the confines of the law and rules when dealing with clients or patients, okay? The other category of entities, organizations, persons, or providers that are required to follow HIPAA law are those that are considered business associates of covered entities, or a BA. And a BA is a rather broad term, and it refers to any person or entity that either works with PHI on a covered entity's behalf, that received PHI from that covered entity in the course of transacting business, or that handles data transmission involving PHI between the covered entity and another agency, okay? So some examples of roles that would fit the definition would be consultants who need to access PHI to audit documentations of hospitals for their quality assurance, for example, or a medical transcriptionist who takes PHI and just transcribes it for a doctor. Maybe an accounting firm who accesses PHI of a covered entity to do their books. So say for like a skilled nursing facility, or legal counsel of a healthcare company who has to access and store some PHI to help their client with a ransomware case, or maybe even an answering service who takes after-hour calls from patients who need refills of their medications from their primary care. So notice the one thing that all of these examples have in common is what they have to access, use, or store in order to do their job. And it's always on the behalf of a covered entity, making them a business associate of a covered entity. So can you be all of those companies and HIPAA not apply? Sure. I mean, the devil is really in the details of the business you conduct and who you conduct it for. Now, typically what happens if you meet the definition of a business associate is you enter into agreements, or what is known as business associate agreements, with the covered entity to follow all the same federal laws and rules that they follow. And again, the keys here are on behalf of a covered entity using PHI to do your job. Okay, those are the keys to the definition of a business associate. So knowing what HIPAA is, what it requires, and who needs to follow it, those are really important to understand, okay? But now we're going to go over some very specific scenarios about where HIPAA applies and who it applies to. And HIPAA can be a really gray area. So this is why counsel should be sought and job duties reviewed to ensure that you are set up to follow the right rules and be educated on the liability and instances where you may need to pass up on an opportunity to avoid HIPAA situations, okay? What you don't want to do is tie yourself to the HIPAA laws when they are not required, okay? Because this would increase your liability as a person or as a business for violating a federal law. So mentioning HIPAA or following HIPAA, advertising it, requiring consent on a HIPAA form, or anything labeled HIPAA ties you into needing to follow the law as you are presenting yourself as such to the public, okay? So now we're going to go over some scenarios of where it applies, and the little nuances in each scenario can really change the answer of whether it applies or not. So I want to pay close attention to the scenario on the screen and kind of the details that are surrounding it, okay? So we've got a news media reporter asking a football player if they are vaccinated during a live news conference on TV. And is this a HIPAA violation? I'm gonna give you a second to kind of think about that in your mind. I'll give you the answer here in a second. No, it is not. And while it may be a private matter to some people, the news media does not meet the definition of a covered entity, and it does not meet the definition of a business associate to interview someone about their own personal information that they volunteer. So reporters are generally not required to follow HIPAA law, okay? You're sitting at home and your physician's practice front office staff member calls you to verify your insurance information for an upcoming visit as a new patient. Does this fall under HIPAA PHI, or protected health information? Yes, it does. The physician is calling about your insurance, which means he plans to submit a claim to that carrier for your visit. So since almost every instance or every insurance out there requires electronic submission of claims, this would make your doctor a HIPAA covered entity. So here's the third scenario. A CAPS general contractor is provided information on a client's health condition from the client's occupational therapist in order to design some adaptations to the client's stairs during a remodel due to their condition, okay? The therapist is not practicing under their license and is only working in the capacity of a consultant to the general contractor and to the client, for which the therapist is being paid privately for those services. In this scenario, does the general contractor have to follow HIPAA? There's a lot of information on the slide, so I'm going to give you a second to think about the answer. Okay. No. Okay. For one, the general contractor does not meet the definition of a covered entity. If the therapist is a consultant and being paid privately and is not a covered entity themselves, then the general contractor doesn't meet the definition of a business associate. Now, could the general contractor get their work done without needing to know personal, intimate details of someone's health condition? Most likely, absolutely. And remember, a client has the right to disclose whatever they want about themselves to you as a general contractor. This doesn't make it protected under HIPAA. You're visiting your dad who's in the hospital. And when you are on the elevator, you overhear a nurse discussing a patient's care in detail to their colleague. And as you continue to listen, you're able to glean enough information to ascertain that, wow, they're talking about my dad's hospital roommate. Would this be considered a HIPAA violation? Yes, it would. Hospitals meet the definition of a covered entity, and therefore all of their workers have to follow the privacy and security laws. So conversations about patients and their care must be conducted in more private areas than an elevator, where others might be able to overhear and determine who they're actually talking about, okay? If no names were used and the person being discussed could not even remotely be identified, it is likely not a violation of HIPAA law, but would certainly and most likely violate probably hospital policy. You're an occupational therapist who works as an employee for an outpatient private practice, and you are licensed in that state to treat patients. And you often refer some of your clinic patients to a CAPS general contractor to become a client of theirs when you recognize a need from working with one of your patients. And so through this relationship with the general contractor, you provide that GC with patient information from your electronic medical record system. You always get the patient consent first. Does this fall under HIPAA? That answer is yes, it likely would, and here's why. The therapist is a practicing clinician who submits claims electronically to insurance carriers and therefore meets the definition of a covered entity. In addition, this therapist is using patient information obtained from the course of their work within that private practice, albeit with patient consent, to work with the general contractor. So if the general contractor is working with a covered entity therapist and is using the protected health information supplied by that therapist to do work for the client, this likely meets the definition of a business associate for that general contractor. Now, the general contractor could totally avoid engaging in HIPAA protected engagements by not accepting personal or protected health information from the therapist about the client. So think about the minimum necessary. Do I need this information to build a ramp? Do I need this information to install grab bars? Probably not. Okay. Here's another scenario. You're a CAPS general contractor and one of your clients' family members provides you with information related to their patients or their parents, multiple sclerosis diagnosis. And you did not ask for this information as the contractor, but it was disclosed to you in the course of a conversation. Is this a HIPAA violation? No. You answered no, you are correct. It is not. A person's family is not tied to HIPAA law. And while it might be private and personal, it's not illegal for you to receive that information from them. And in the last scenario, you're a general contractor and you're working with a durable medical equipment company in your area. And you use this company to come out and install a wheelchair ramp in your client's home. And you have no medical information on this client, and you don't share any information on the client's health condition with the company, but rather provide the need, provide the measurements, and then you hire them to do a job. Does HIPAA apply to the general contractor in this scenario? If you answered no, you are correct. A general contractor doesn't meet the definition of a covered entity or a business associate and isn't using PHI to conduct their business with that medical equipment company. Now, there are DME companies who do meet the definition of a covered entity or a business associate, but that doesn't necessarily impact you if you aren't using any PHI that they provide to conduct your business affairs. So remember, we said the devil is in the details. It's about who you're working with and the context of the business practices that you're conducting, okay? So this leads us to the next topic of conversation. And so hopefully after going through some of these scenarios, you can start to see the difference between HIPAA law and what would be considered potentially privacy and confidentiality. And while it's not always cool to reveal sensitive or private information that you may know, learn, or be exposed to, it's not always illegal either. And there's a difference between being required by the law and being permitted by a person to protect the use and disclosure of their health information. So if you are not required, and that's the key word, by law, then stating you follow the law or having clients sign acknowledgements that you do puts you as an individual or a business at a liability to follow it and all the consequences that come along with not following it, right? If you're required to follow HIPAA by law, you have to follow each and every single rule and requirement. You can't pick and choose what HIPAA privacy and security rules you want to follow or what's easier or cheaper to implement. So you can see that following the rules when you aren't required to do so can be a liability risk for your business, okay? If you're not required to follow HIPAA, It is still best practice to ask the client for their permission for you to receive private details about their health status or their care, and let them know how you plan to keep that information confidential and have them sign it only if you need it to do your job. Okay. And really, you need to heavily consider if you even need that level of detail to do your job. So, this signed statement, which is known as a privacy and confidentiality statement, should be developed by your attorney. Okay. So, keeping things private and confidential, whether that's conversational or whether that's in the form of data, is not HIPAA necessarily. So, a waiver and release of information could help protect your business as long as you adhere to what you say you're going to do. And it helps give comfort, I think, to the client that they can trust you with intimate details about their life. And so, if the client is unable to sign themselves due to a physical or a mental incapacitation, you would want to have their power of attorney, their medical power of attorney, or their legal representative sign that waiver and release of information. Okay. On these last two slides, I'm going to provide some recommendations for therapists and GCs as it relates to HIPAA. And again, this is not legal advice, and they're just scenarios for you to run by your own attorney or your compliance officer to come up with what the proper business solution for your unique business needs really is. So as an OT, you can work with general contractors in the capacity of a consultant and not necessarily be considered a covered entity, which means that HIPAA would not apply to you. And there are ways to structure this and certain actions to take, and there are certain actions to avoid. And so, assuming you do not fit the definition of a covered entity and you aren't practicing in the clinical sense and using information from your practice to consult with that general contractor, you could work with your business attorney to draft a waiver and release of information for which your clients could sign that promises your confidentiality with any health information that that client would share with you. And so that information should be on a need to know basis and only strictly for the purposes of doing your consultant work with the CAPS general contractor. And keep in mind, a client can share whatever health information they want with you as a private citizen or a private consultant, and it doesn't necessarily constitute HIPAA, but ensuring that is best to run through legal. You always want to make sure that you are set up properly if you're doing this as a business, okay? If you are a practicing clinician who uses health information of clients or patients as approved, and if you're functioning in the capacity of a healthcare worker who is using, accessing, or disclosing protected health information for use in the work that you're doing with the CAPS general contractor, you likely implicate HIPAA and likely will implicate your partners in it as well. So if you need and should follow HIPAA, or if you're unsure if you should, there are really a few recommendations that I have for you. Always speak with your employer to ensure you're following the proper use and disclosure policy and procedures if you're using any information from your job to work with a general contractor. Okay, spend the money, get an attorney. It will save you a lot of heartburn and dollars in the long run if you make a mistake or you don't set yourself up and market yourself appropriately. Okay, it's really crucial to ensure full compliance with state and federal law. So it gets complicated, and that's why you need to consult with an attorney, okay? And then you want to ensure you get the proper business associate agreements in place and that you have very frank discussions with anyone you would work with in the capacity as a general contractor that don't normally maybe follow HIPAA guidelines and rules, because you don't want to put your partners at risk either. You won't have a business at that point. So in these agreements with your business partners, you have to attest to being fully compliant with all the HIPAA privacy and security regulations. And keep in mind, if you subject partners to HIPAA necessarily or even unnecessarily, it may jeopardize your reputation and limit your ability to work with certain contractors, okay? For general contractors, generally you are not required to follow HIPAA, and therefore to keep your personal and business liability to a minimum, it's best you consult with an attorney on the proper setup and waiver and release of information with your clients and consultants. So highly consider working with other consultants who will not subject you to following all the federal privacy and security laws. And also never sign business associate agreements that tie you to HIPAA without ensuring with your attorney that you should actually be doing so. So in all honesty, you shouldn't need PHI to do your job in most instances, okay? If you do consult with a practicing occupational therapist who's required by federal law to follow HIPAA, and as a result of their business dealings with you, shares that information so that you can do work on behalf of their client, and using or accessing their protected health information, you should do a couple of things. Work with a healthcare attorney to set up a proper HIPAA compliance program, create and enforce all program requirements with your staff and in your offices, draft your business associate agreements and use them with all the covered entity consultants that you would work with, and then work with a third-party contractor to regularly audit your compliance with the law. And so the same applies here. It is worth it to work with an attorney, ensure that this is set up properly at the beginning, and to learn what to sign, not sign, use, not use, disclose, not disclose. Very, very important for your business liability, okay? So I have my contact information here if you need to reach out to me with further questions. But for now, Steve, I think we'll open up the floor and address any additional questions at this time.
Yeah, terrific. Great presentation. Lots to think about. So if anyone has a question, just go ahead and pose it to Meredith.
This is Cheryl. I don't have a question, Meredith. I just wanted to thank you for the excellent information you provided us today. It was excellent information. Some things I didn't think about at all, but you answered my questions during your presentation. I just wanted to thank you for the excellent presentation. So thank you.
Absolutely.
Questions may come up in the future. I may reach out to you, but again, thank you for the information.
Sure thing.
And just to that point, Meredith, we haven't discussed this, but consider your willingness and availability to be a consultant to anyone who has additional questions on an hourly basis. If that's something that's palatable to you, that would work well, I think.
Absolutely. I do consulting in a HIPAA capacity for a variety of different clients. I've been asked to serve as the privacy officer for different businesses where they outsource different activities and responsibilities of the officer to me. I'm here to answer any questions that you may have. And again, obviously not an attorney, but am certified in this space.
Someone else, please.
No, like Cheryl said, this is Melba. I want to thank you, Meredith. A lot of good information. I am an occupational therapist and I have been trained with HIPAA for so many years, but I learned so many new things today. Very interesting. I think that I will have more questions as I review all the information that you gave us today, and I will probably get in touch with you.
Sure, absolutely. HIPAA is a very complicated subject, and the crazy part about it is, you know, we're taught as clinicians the laws and the rules as it relates to the policies and procedures, mostly of our employers, and it's a lot more gray area than I think most of us want to admit.
Meredith, this is Patricia. This may be more of a question I need to direct to legal, and that's fine if it is, but I'm curious if when you meet with a client, if you explain to them that they're free to share information, but you won't be requesting any, does that, like medical information, does that open you up to having to follow HIPAA? Or if you preface it with that disclaimer, sort of?
Yes, so that's a really great question. I think the very first thing you need to do is determine if you meet the definition of an entity or organization that has to follow HIPAA law. So if you have to go through that process and say, am I a covered entity or am I a business associate of a covered entity? Because that's really what determines how you have to present yourself to a client. So if the answer to either one of those is yes, then you have to follow all the HIPAA laws and rules. If the answers to both of those are no, then that would be where privacy and confidentiality come in, and it would be worth it to have your attorney to protect you and your business entities set up the right language for a waiver of release and liability about the information that they volunteer to you and what you would do with that information to keep it private and confidential. And you can't just present yourself and say, I'm going to do X and not do X, right? So you want to make sure that whatever you're telling them that you're going to do is what you follow. So I think the very most important thing first is determine whether you are required to follow federal or state law. And the reason that I think it's so important to work with an attorney to get your business set up the right way is because there are differences by state. So if you are somebody that lives in the state of Florida, for example, and the Florida privacy HIPAA security rules are stricter than the federal, then you have to follow those. And we are strictly talking about federal law today. We're not going into all the nuances in different states. So I think it's really important that you determine that first, and then you determine how you present yourself to client. Because if you put something on a piece of paper that says you follow HIPAA, whether you are a covered entity or a business associate or not, you are liable for following all of those in the eyes of the government.
Right. Are there specific attorneys that you should look for that specialize in this, or is it any,
yes, I would, me personally, I would go straight to a healthcare compliance attorney. It's worth the couple of hours that, maybe 2 hours tops, 3 hours tops that they would need to, look at your business practices, determine whether you have to require it. Now, if you do require it and you need to build an entire whole program around it, that's going to cost you a lot more money, but they might be able to say, here are ways that you can work within the confines of your business, still meet your, obligations to clients and operate within a lower liability context.
Perfect. Thank you.
Great questions.
Yeah. Anyone else?
My name's
Go ahead.
Nancy. Thank you, Meredith. I really appreciate this. Is some information. I think I got all the questions right, which I was really excited about.
Yay.
However, I'm just curious, and correct me if I'm wrong. I work with a home health agency, and if I use this certification in that capacity, I am bound by HIPAA because I know that patient's healthcare information. Am I right?
Well, it depends on what you're using and accessing and how you're presenting yourself. If you are working with a general contractor as an employee of that home health agency, that's completely different than you operating as a consultant who just happens to be licensed as an occupational therapist, but you're not practicing or using any of that information that you obtained from your job in the context of doing business with a general contractor. So it's really how you're set up to work with that general contractor. I'm sure that it just be a referral situation where I'm sending you a referral. It may be we've got a business contract. You have to look at how you're set up and how you are working with that particular general contractor. So if you are an employee of that home health agency and you are using information on patients that you obtained as an employee of that home health agency, and you are sharing that referral, even if it's their name, you're sharing that with a general contractor, that most likely implicates both of you. So you have to really look at the context of how you're engaging in business with an attorney or with your employer, so that you can determine that you're following all the laws and rules. And oh, by the way, if you're doing it in the context of as an employee of an entity, that you're following all their policies and procedures, because you don't want to put your job at risk either.
Thank you.
That was a good question. Anyone else? If you have additional questions, send them to me, and I'll forward them to Meredith, or go ahead and reach out to Meredith directly.
And then Steve, if you want to provide the PDF slides of this to this group, I think I sent that to you as well. And it will also have my contact information on it.
I will do so. And we did record the session, but we had that glitch in the middle with that bleed through. And I don't know if we can take that out, or if we'll go from when we started again, or how that's going to work. But it'll take, it won't just be sent out immediately. We'll have to go through that before we can get it to you. So give it a day or so to get the recording out to you. But I will send out the slides to everybody.
Okay, I'm going to go ahead and stop the recording here.
All right. Thank you, everyone.
Thank you very much.